Unit 1 essay questions. The first essay question is argument. The other ones are constructive essays. I'm going to go over the main ideas, the main things for you to think about. I would like each of you to write an argument essay using the information that I gave you. You can add to it. You can do different answers, but I'm going to give you both pros and cons, and then you can do the constructive essay. And I want you to turn in 2, and that'll be on Wednesday by midnight. You can work with a friend and you can talk with them and go over it. Also put it in your own words, make it your own writing, make it your own. Also, I'd like you to please tell me whether you are taking the AP test or not. So let me know when you write the essays. Is this for check for understanding, or is this for an assessment? And tell me whether you're taking the AP test or not. So the argument essay for Unit 1, this is from the AP Central. The federal government can share revenue with state governments through grants. Some grants, such as categorical grants, place constraints on how states are allowed to spend money. Other types of grants, such as block grants, allow the states greater authority to determine how the money is spent. Develop an argument that takes a position on which type of grant best serves the interest of citizens. Use at least one piece of evidence from one of the following foundational documents: Brutus 1, Federalist 51, the 10th Amendment of the Constitution. In your essay, you must respond to the prompt with a defensible claim or thesis that establishes a line of reasoning. Support your claim with at least one piece of specific evidence and relevant evidence from one of the foundational documents. That's Brutus 1, Federalist 51, or the 10th Amendment. And then you also need to basically refute the other side. State a reason why the other type of grant is not best to serve the citizen. So always make sure that you do that. Now, when I look at this essay, I look at the documents. Brutus 1 is an anti-federalist paper, and the 10th Amendment is the reserved powers of the Constitution. It reserves all powers that are not delegated or explicitly written. They are not denied to the states, go to the states. So 2 of the documents are actually allowing or wanting the states to have more power. Federalist 51 is about checks and balances and separation of powers. So you need to look at this and what is a block grant and what is categorical grant. So a categorical grant, there are 4 different types, but this is where the federal government puts strings on the states. So you can have grant in aid, you can have program grants, you can have formula grants, and you can have project grants. And some examples of a categorical grant is where the land grant schools in the Morrill Act of 1862 created land grant colleges, and they basically gave land and they gave money to states to have higher education, but they did require states to, with the education, they had to give a report to Congress, and students had to be part of the military or have a military aspect to the education. Another example of categorical grants are grants that go to states for transportation, like to build an airport. Another one is Head Start, is a categorical grant. Medicaid is a categorical grant. And the transportation, way back from 1916 all the way to right now for the age of 21, was a categorical grant. States could not get funds and money unless they actually raised the drinking age to 21. So this was a requirement. Block grants are where the federal government gives money to states, and they give a lot of leeway to states for actually spending their money. TANF, Temporary Assistance to Needy Families, our welfare reform in 1996, is a block grant where it gives the money to the states to handle their welfare programs. And the states can do anything they want to with that money. There's block grants with housing and urban development. There's also special services block grants, but the federal government gives the money to the states, and the states can do whatever they want to. There's no strings attached. There's no review. There's no seeing how the money is spent. So in the past, after some research with TANF and welfare, states specifically spend about half of the money that they get from the federal government on welfare, and then the other half goes into other programs. So they can spend the money in any way they want to. With a categorical grant, the states cannot spend the money however they want to. It has to be spent on the specific purpose, the specific way, and there is follow-up. There's things how it's done. So you have to develop an argument, takes a position on which type of grant best serves the interests of its citizens. So if you're definitely a conservative, if you're a Republican, if you believe in, like Brutus and the 10th Amendment, the two of the documents are on that side. Because remember, Brutus number 1 basically states there is no real good large republic. Any large republic is tyrannical. Only the local area, the local people know what's best for themselves. So when you're looking at Brutus number 1, they're stating that the citizens know best, and representatives can only represent people at the lowest level possible. The 10th Amendment basically states that if it's not specifically written in the Constitution and it's not denied to the states, it's reserved to the powers of the states. So that would be like education, that would be marriage laws are reserved to the states. And then Federalist 51, of course, is with checks and balances, and the republic is the best. Representative government is the best way to control factions and control different ways. So in this one, you have to say which is better, categorical grants or block grants? Which is better to serve the interests of citizens? Which best serves the interests of citizens? So if you think that block grants are the best, you need to state that, use Brutus number 1, use the 10th Amendment, where at the local level, the state and local officials know what their citizens want, know how best to deal with them. So typically in the states, they know what their citizens want. The citizens might be the same religion. They might have the same belief about guns. They might have the same belief about taxes. They might have the same beliefs about government power. So if you're looking at certain states, they might believe in limited government. They might believe in small government. They might be low taxes and those things. So you would use Brutus 1 or the 10th Amendment and say that block grants are the best because that gives the states the power to determine what's best for their citizens. Many Republican states don't believe in welfare and believe it should be limited and less. So if you have a block grant with TANF, they can determine how much money goes to their citizens. They can determine rules. They can do drug tests. They can do other things, and the money goes to where it's needed. And if the state determines that it's not needed for welfare, but it's needed for roads or needed for education or something else, they can put the money where they want to. So remember on this one, not only do you have to take each point, so you have to have 2 points, you must state that block grant or categorical grant are the best, serve the best interest of its citizens. So for every piece of evidence, you have to use Brutus 1, Federalist, or 10th Amendment. We have to use one of those to do it, and then you have to use another, either Supreme Court case or another law that follows up with what you're doing. Use federalism with this and use grants and different types of grants and different laws that best serve the interest of its own citizens. So remember, you have to basically state for each point of item that this is the best for its citizens. And then you have to go back and say, because of this evidence, Brutus 1 or the 10th Amendment, that a block grant is best and it's better than a categorical grant. Now, a categorical grant, if you have Head Start, if you have Medicaid, if you have certain large programs, the federal government is serving all of its citizens and they tell the states what they have to do. If you have a welfare program and it used to be a categorical grant, they basically made the states give their citizens welfare, and they gave the formula and they gave that. They gave states money for colleges, and colleges had to follow these rules. They couldn't move the money around. They couldn't do anything else. They couldn't move the money over. So one of the advantages of a categorical grant, the states can't move the money wherever they want to. They have to use it for whatever the government says, and that could be for the best of their citizens. If you're caring about welfare or young people with Head Start, if you're caring about colleges, you don't want the states to move the money into a different program. So you have to use, in this case, probably Federalist 51 Or you can use Brutus 1 as the argument against the other side, but you do need to use Federalist 51, I would say, and then use another law, another grant. So you'd use another categorical grant, whether it's the land grants, Head Start, highways, raising the drinking age to 21 was best for citizens, reduce deaths, reduce highway accidents, reduce that, and it gave states the money for doing that. So please, on the argument essay, make sure you have a thesis, and the thesis should state because and give two reasons, and the two reasons should be your two pieces of evidence and the reasons for that. Also remember, for every reason that you have, tie it to the prompt. Block grant, categorical grant serves the interest of the citizens, and which grant is better, the block grant or the categorical grant. So always tie it back to the prompt, tie it back to the thesis, and then refute the other side and say, even though block grants are good and the states can use their money as they see fit and they know it, but because of what states do, only half of the money goes to welfare and the other half goes to other areas. So a categorical grant is better for the citizens because all of the money that was supposed to go to welfare and the poor actually go to welfare and poor, something like that. So make sure you have the refuting statement at the end. So if you have any questions, feel free to ask, but you do need to write an essay about this argument. Block grants, categorical grants allow state or states authority to determine how the money is spent. Develop an argument that takes a position on which type of grant best serves the interest of the citizens. Okay. Constructive, number one, federalism. Framers of the Constitution devised a federal system of government that affected the relationship between national and state governments. Compare state sovereignty under the Articles of Confederation and under the Constitution. So A, you would basically put all of the powers of the Articles of Confederation. States could tax, states could raise an army, states had all of the power, they could make their own money, they regulated trade, they were independent countries. And then under the Constitution, state sovereignty was below national sovereignty. The Constitution and federal laws, federal decisions, federal court decisions was supreme over states. So states had to take a back seat. Under the Articles of Confederation, states were above. It was just a league of friendship, and there were 13 independent countries. And under the Constitution, there is one country with 13 states, and the states were subservient, and the Constitution was supreme. Explain how each of the following has been used to expand the power of federal government over the states. The Commerce Clause is used to expand the power of the federal government. Congress has used the implied powers to do that. We've used the Commerce Clause for civil rights. That was a main one. We've used the Commerce Clause for Social Security, for Medicare, probably even Medicaid also. Any of the New Deal programs, Commerce Clause was used, regulating trade to do that. Minimum wage is trade, who you can hire and fire, any of the workplace rules and laws using the Commerce Clause regulating trade. Mandates or orders from the federal government to the states to do something. So one of the mandates that you might have is Brown versus Board of Education, that states needed to desegregate schools. Mandates would be Clean Air, Clean Water Acts. Mandates would be the Americans with Disabilities Act and having ramps and handicap parking and wheelchair accessible places. All of these are mandates that the state governments, it basically rules telling the states they must do something and follow something. So the expanding the power of the federal government over the states, the Commerce Clause, big mandates. Is number of mandates can be a law, but a mandate could be a Supreme Court case decision. Obergefell versus Hodges, where gay marriage was allowed, was a mandate from the Supreme Court to the state saying you must do this. Some mandates are funded, some mandates are not funded. Now explain how each of the following has played a role in the de-evolution of power from the national governments to the states. So block grants, they basically are ways to give more power to the states. States can have the authority to say what they spend their money on. Their money is given to them for a block of different programs. They're broad programs. block grants that I've mentioned were TANF, or welfare programs, social service programs, HUD programs, housing and urban development, where the states get to do whatever they want to with the money. They're given the money, and then they can use how they want to. So the states are now given more power to basically use the money and how they are. Supreme Court decisions have also played a part in limiting the power of national government to giving more power to the states. U.S. versus Lopez is a landmark Supreme Court case which said the Commerce Clause was overused or unconscionable use of it. The Gun-Free Zone Act Congress passed. A gun-free zone around schools had nothing to do with the Commerce Clause. There is U.S. versus Morrison was another Supreme Court case where it was about rape and about victims' rights and suing for damages, and this again had nothing to do with the Commerce Clause or the power to tax. So the Supreme Court said that this was an unconscionable use of the Commerce Clause. So Supreme Court decisions have limited the power of the Congress and national government over the states and limited their powers and said, no, you can't do this. So you can look up some other decisions that you'd like to. Those are two that you can use. You can use, and remember, it says explain how each of the following has played a role in the de-evolution of power. So block grants and Supreme Court decisions. You only have to give one example for each. So I've given you two for Supreme Court decisions, block grants, giving you those. Constructive essay. Number 2. Each policy-making institution in the United States federal government is subject to restrictions on its powers. So explain how each of the following can restrict presidential power. Power of the purse, appointment, confirmation power. So the presidential power, the power of basically to be commander-in-chief and send troops over to overseas. The Congress can say no. They don't have to declare war, but they can say to the president, look, I'm not going to do this. We have the power of the purse. We have the power to fund this. So the Congress can restrict presidential power by limiting the money for that war. President Trump has wanted to build the wall and use federal money for building the wall, but Congress can actually take money away from the Defense Department or whatever authority the president is using for that, because the only group that can actually fund or have the power purse is Congress, and Congress can take the power away from the president by taking away the money. The appointment confirmation process, the president can appoint judges, they can appoint department heads, they can appoint ambassadors, but the Senate has the confirmation process, and they can deny any nominations, whether they're not qualified, whether they are qualified, based on political purposes, and that can restrict presidential power. So the confirmation process can limit the power. Now, typically it happens when the Senate and the president is of different political parties. So if the president is a Republican and the Senate is Democrat, they cannot approve the justices or appointments of the president unless they are, say, maybe middle of the road or not so extreme, or if they're very qualified, they'll do them. Explain how each of the following can restrict congressional power. Presidential power is commander-in-chief. Congress has the power to declare war. Congress has the power to make rules for the Army, Navy, the militia, but as commander-in-chief, the president can and has committed troops to Vietnam War, the Korean War, Grenada, Iraq, Persian Gulf War, War on Terror. And this restricts congressional power to declare war, and even just in war-making processes or even in foreign affairs. So the presidential power as commander-in-chief is very strong, and it can restrict congressional power. The president is one person. They need to act quickly. They can do this very quick over having a vote of basically 535 people determining and debating this. Executive privilege restricts congressional power. Executive privilege is the ability to debate issues and debate going to war, foreign affairs, issues that they can keep from Congress. And executive privilege has typically been set and have been allowed in foreign affairs, where you want a free-flowing thoughts. You want all the different ideas out there. You want to protect your advisors. You want to protect the people with the ideas. You don't want everybody else knowing what was talked about. You don't want the public, the press, other Congress to know all of the different ideas out there. You want to protect your players in that, and that's executive privilege. Now, it is typically with U.S. versus Nixon, executive privilege is not allowed for wrongdoing. It's not allowed for domestic affairs in many cases, for like political campaigns or something locally, but they will allow executive privilege for war, for foreign affairs decisions, and things like that. Explain how each of the following can restrict judicial power. Enforcement of judicial rulings. So Andrew Jackson was the most famous one with the Trail of Tears in the Indian Removal Act, where the Native Americans were to be moved from Georgia and going out west to Oklahoma, and Andrew Jackson did not enforce that. And there's nothing requiring the president to enforce judicial rulings. Eisenhower did enforce Brown versus Board of Education, and did send the 181st Airborne down to Alabama to get the schools desegregated. But there's nothing saying that the president has to do that. And there's many people that would believe President Bush, President Obama, President Trump would not enforce rulings that they did not like and did not want. So if the executive is in charge of enforcing the rulings, they don't have it. There's nothing that says anything in the Constitution that they have to do that. And then constitutional amendments can restrict judicial power. So one of the famous cases was the Texas versus Johnson. That's where the Supreme Court said that flag burning was constitutional. And with that, the Congress very quickly, bipartisan wise, it passed the Congress 2/3 vote that burning the flag was unconstitutional. It's gone to the states. The states have not approved that, but they haven't done that. But this is the example where Congress can try to restrict judicial power with a constitutional amendment. So if there was an amendment that was passed that says you cannot burn the flag, and it went past with 38 states, that would limit the judicial power. They can't say that was unconstitutional, not an amendment supersedes this. So the famous example that did happen was Dred Scott, that said slaves were not people and they were property. And then you had the 13th, 14th, and 15th Amendment, which basically made Dred Scott unenforceable and not there. So that's a couple cases where if you have a bad Supreme Court case, you can actually pass an amendment to actually restrict the power of the Supreme Court. Constructive essay number 3. The balance of power between the United States national government and state government is shaped by the Constitution, Supreme Court rulings. Describe each of the following constitutional provisions. So you have the Supremacy Clause, which is for the strong national government, and that basically gives the power of the national government over states. So that states that all of the laws, all of the decisions, all of the treaties, the Constitution is supreme law of the land, and it has power over the states. The state cannot nullify laws, cannot nullify rulings. The Constitution is supreme law of the land. The 10th Amendment is your reserve powers to the states, that says basically in this amendment, if it is not expressed in the Constitution and it's not denied to the states, the power goes to the states. So there is this tug and pull between the implied powers and the 10th Amendment. Supremacy Clause, the federal government is supreme. The 10th Amendment says, well, if it's not listed in the Constitution, it goes to the states. So that's the balance of power. That's the struggle in that. Now explain how one of the following court rulings has changed the balance of power between national governments and state governments. So U.S. versus Lopez. This is a case where the state government was given more power. It actually was reduced the federal government's power. So Congress made a law stating that there's a gun-free zone area around schools, and they used the Commerce Clause, and the Supreme Court said, nope, you can't do that. Interesting on this, Texas made a law in Texas passed a law stating there cannot be guns around schools. That law is constitutional. States can do that. But the U.S. government, because they can only do those expressed powers, power to tax, power to um, regulate trade, the power to coin money, the power to declare war. If it's not related to one of those express powers, they can't use the implied powers. Now, Obergefell versus Hodges is the gay marriage, which basically was the Supreme Court case that overturned all of the state laws stating that marriage was between a man and a woman. This is a Supreme Court case that said gay marriage was now constitutional and legal in all 50 states. So this changed the balance of power between the national government, state government. Typically, marriage has been a state ruling. Most states make your laws about marriage, when you can get married, what the requirements of marriage are, how old you have to be to get married, the licenses and things like that. But Obergefell versus Hodges is where the federal government, and specifically the Supreme Court, got involved and said all of these rules that says marriage is only between a man and woman, those are null and void. Gay people, gay men, gay women can be married. Describe 2 advantages of federation for the creation of public policy. Advantages of federalism for lawmaking is there's more people that can participate. There's more ways and access points for people to create policy at the state, local, and federal level. It can be efficient at the lower levels. Federalism can stop one group from making too many laws and being tyrannical. It can stop the federal government from doing something. States can do that. I know there was a case where in Virginia, we wanted the supersonic flights between DC and France, and the local area stopped that. So it's an advantage that, of federalism to stop things or stop one branch of government from being too powerful. But typically, I look at the creation of public policy is where advantages of federalism is more people get involved, more people can run for office, they can get involved in a local issue, they can vote. And you can have different areas of public policy where you might not be able to do something at the national level, like we might not be able to make background checks for guns at the federal level, but at the state level they can be made. If it's hard for a law to be passed, federalism allows little laboratories for the states to do. So we had welfare with work requirements in different states, and that was seen as a success. Obamacare was first tried out in Massachusetts. It was called Romney Care. It was a successful program of healthcare that they used and went to the national part. So there's advantages of federalism for creation of public policy. It's like a laboratory. It's like a way to test things out. Kansas got rid of income taxes and got taxes and cut things, and they did very libertarian, limited government things to see if that's successful or not. We've used vouchers at the state level as a way to do a conservative method for education. So it's a way. Federalism advantages are really more people can participate. You can participate at different levels. There are laboratories for experiments, and it's a way to get policies done. If you can't do it at the national level, you can do it at the state level. Number 4. In Federalist Paper number 10, James Madison expressed concern over the possibility that both the majority and minority factions would have too much power over the government. He presented ways of minimizing that danger. The U.S. Constitution established a democratic government, but also contains several provisions that limited majority rule. Throughout the next 2 centuries, the role of the majority rule in the U.S. government and politics continued to change. Identify the part of the national government that was originally most closely tied to citizens and how it was tied to citizens. B, explain 2 ways the Constitution limited majority rule. C, choose 2 of the following 20th century developments and explain how each moved the U.S. from a less democratic to more democratic system. Primaries, 17th Amendment, expansion of suffrage. Okay, so on this one, the part of the national government that was originally most closely tied to the citizens, it was the House of Representatives. The House of Representatives was elected every 2 years, and they were directly elected by the citizens of their state or their congressional district. At the time of the original Constitution, The Senate was not elected by citizens, nor was the president. So the only group in the national government that was most closely tied to citizens was the House of Representatives, because they were tied closest. Now you can say Senate was next because the state legislatures, which were voted on by the people, could choose who the um, senators would be. But the best answer is the House of Representatives. They were tied to the citizens because they had the lowest term, they had the shortest term, 2 years. They were constantly up for reelection, and they were constantly put up. If they did a bad job, they could be pushed out because somebody else could be voted in. And they were the only one that was directly elected by citizens. Two ways the U.S. Constitution limited majority rule. One was the uh, election of the president with the Electoral College limited majority rule. So that was a case where the president was not elected by people, and it was elected by the Electoral College when the electors were supposed to be chosen by the elites in each state. So each state would determine who the electors would be. They were supposed to be smart, wise people that would choose the president based on what they felt was the best. The other way the Constitution limited majority rule was the election of senators was done by the state legislatures. It was not done by popular vote. So those are two ways the Constitution limited. The Constitution also created a republic. It created a republic with checks and balances. It created a republic where there was not direct democracy. Voting wasn't even mentioned in the Constitution. Who could vote, who was allowed to vote was not even mentioned. It wasn't a right in the Constitution. And the founding fathers definitely did. They did not like majority rule. They were afraid of the majority overruling, and in their case, the minority, which was the landed interest or the wealthy. So they were definitely afraid of that. So the state legislatures were in charge of electing senators who were there for 6 years. The president, who was the head of the executive, was there. The judicial branch was not even elected whatsoever. They were chosen by the president and confirmed by the Senate. The two least tied to citizens, limited majority rule, and they were there for life. So it had quite a few ways where it limited majority rule. Then you look at in the 20th century, we went from a less democratic system to more democratic system. We went from a caucus system in the 1800s, convention system, to primary. Primaries are where people actually vote for people in the political party to try to choose the nominees. So the party bosses, the party officials are not making the decisions on the nominees, but people are making the decisions. So primaries became more democratic. Both Republican and Democrats have used a primary system instead of a caucus or convention system, even though we do still have caucuses and we have conventions at the end, but primaries are the primary way that we actually choose our nominees. The 17th Amendment called for the direct election of senators, not from the state legislatures, but by direct election by people. So the 17th Amendment created a more democratic system where people in the state voted for the senators. So if you look at Arizona, Arizona had Kristen Sinema was elected, but in that case, if we went by the old way before the 17th Amendment, she never would have been elected. The state Senate, state legislature in Arizona has been typically Republican forever, and it's been Republican. The governors have been Republican. There's been a few Democrats, but the legislature and the government would have to determine the senators, and there's no way that Kristen Sinema would have been chosen by Doug Ducey or the legislature. Doug Ducey and the legislature picked the replacement for Jeff Flake's seat, and they picked Martha McSally. And if there's another person that needs to be filled, they would pick a Republican for that way. So that's kind of like the 17th Amendment became more democratic. Expansion of suffrage from the removal of the property requirement, the 15th Amendment allowing African Americans, the 19th Amendment allowing women, the 26th Amendment allowing 18 years or older, so younger people could vote. the amendment that allowed Washington, D.C. to vote, the amendment that got rid of the poll tax. All of these things, systems made it more democratic, made more people get involved. The electorate has grown. The electorate has grown. The number of people allowed to vote has grown. And it's not just white males voting, it's women, blacks, Hispanics, and it's made it more democratic from less democratic. Essay number 5. Constitution was an attempt to address the problems of decentralization that were experienced under the Articles. List 3 problems of decentralized power that existed under the Articles of Confederation. For each problem you listed, identify one solution that the Constitution provided to address the problem. So in A, the Articles of Confederation, the national government could not tax. So this problem was solved by the Constitution, where Congress had the power to tax. The Articles of Confederation had to ask the states for help in putting down a rebellion or manpower, or couldn't raise its own army. In the Constitution, the ability to raise and support an army, raise and support a navy, to raise and support a militia, that was all granted to Congress and the national government. There was no In the Articles of Confederation, there was no way to regulate interstate trade. Each little state was its own country, and they had their own arguments. There was no referee. Well, the Constitution allowed for the judicial branch to act as a referee and determine which state would be correct. They could interpret the laws and see whether a law was constitutional, whether state law was constitutional, federal government was constitutional, if there was disagreement between states, who would win, who would lose on that case. So the judicial branch was allowed to do that. There was no executive in the Articles of Confederation, so there was no way to enforce any laws that were passed, if there were any, were passed by the Articles of Confederation. And in the Constitution, there was the executive branch. The president was created. Article 2 was created, and they were able to enforce laws that Congress passed. So those are many of the problems that were under the Articles of Confederation. There wasn't the power to tax, there wasn't the power to enforce laws, there wasn't the power to interpret laws, to regulate trade, to regulate commerce, and they were all solved by the Constitution. Some have argued that the tensions between decentralized and centralized powers continue to exist. Support this argument by explaining how one of the following, so you only have to do one, illustrates the continuing tension. Environmental policy. So environmental policy, who is in charge of it? Typically, it's the national government with the Clean Air, Clean Water Act. The Environmental Protection Agency tells the states and gives mandates to states on what they have to do, and they have to tell states that they have to follow these rules and these laws. States are saying, no, they're too hard to do. There's too many regulations. We can't do this. And it's a power struggle between national and state. And environmental policy typically has been the federal government giving mandates and restrictions to states on what to do. Gun control, whether it is background checks, whether it is conceal and carry, whether it is AR-15s, whether it's ammunition, all of this is a fight between, can the Congress pass a law, can the states pass a law, who is in charge of doing that? So President Obama had passed some executive orders to regulate, background checks and trying to tighten loopholes, that if you're on the terror watch list, you can't buy a gun. If you're a criminal, you can't buy a gun. And then states have tried to fight that, and states have tried to say, no, you can't do that. It's my Second Amendment right. So we've had 2 Supreme Court cases. DC versus Heller created the individual right to own a gun is an individual right, and then Chicago versus McDonald applied that to the states. So gun control is still an area where it's a basic right. It applies to the states, but there is this argument between what gun control is allowed, what's not allowed, and that's a big fight between that. And then disability access is another issue where the federal government has made mandates, whether it's through the Americans with Disabilities Act, whether it's with IDEA, where it's Individuals with Disabilities Education Act. Disability access is where you need bathrooms that have wheelchair accessible, whether you have parking spots close to the area, whether your buildings have wheelchair accessible, whether you have elevators, all of this. These are mandates that the states have to follow. And if states don't follow it, they can be fined. Builders can be fined. There can be issues with that. So this is an argument. This is a tension between the central power and the state's power. Decentralized is typically local. State and local should do it. Centralized power is the federal government telling states in local areas what to do. In disability access, it's the federal government's not only telling the states to do something, but local cities, local areas, local businesses what to do. So you need to support this argument with one illustration in one of those areas. Constructive, number 6. The framers of the Constitution created a federal system, defined federalism as the division of power between state, federal, and local areas. Select 2 of the following, so you only have to do 2, and explain how each has been used to increase the power of the federal government related to states. So categorical grants are formula grants, project grants, grant in aids, where basically the federal government gives money to the states but tells the states how they have to spend it. It would have to be on an airport, have to be on transportation, it would have to be Head Start, which is morning programs for kids or afternoon programs with kids in schools. It's both. Medicaid is healthcare for poor people and how it has to be spent. So these categorical grants increase the power of the government relative to states, and they tell states what they have to spend their money on, what they have to do. Federal mandates is any law, any act, any judicial act, any executive order that goes from the federal government to states. That could be the Clean Air, Clean Water Act. That could be Brown versus Board of Education. That could be the Highway Act increasing the age from 18 to 21. These are all federal mandates that the federal government says the state, you must follow this and do this. Another federal mandate at one point was 55, was the nationwide speed limit that the federal government said everybody had to follow, including people in the West, and that caused them very much upset, but it was a nationwide thing for a while. And then selective incorporation increased the power of the federal government. This is where the Supreme Court basically incorporated the Bill of Rights, the freedom of speech, freedom of religion, freedom of press, freedom of right to bear arms, and applied it to the states. So these were originally Congress shall make no law abridging freedom of speech, but then it was applied to the states. States could make a law abridging the freedom of speech. So the selective incorporation of the Bill of Rights and the amendments to the states increased the power of the federal government and applied that to the states. So states couldn't have segregation. States couldn't have rules that restricted African Americans' voting rights. They couldn't have literacy tests. They couldn't have poll taxes. They couldn't have white primaries and rules against people with, saying bad things about the government, censoring government, and those kind of censoring publications couldn't be done. So selective incorporation took the Bill of Rights gradually over time and incorporated them in states and increased the power of the federal government relative to the states. Then select 2 of the following and how each has been used to increase the power of states relative to. Sorry about this. There we go. These 2. Select 2 of the following, how they've been used to increase the power of the states relative to the federal government. So the Welfare Reform Act of 1996 changed welfare from a basically lifelong welfare to a welfare program between 2 and 5 years. That's where TANF, Temporary Assistance for Needy Families, was created. It was a block grant program. It was originally a categorical grant program. Now it's a block grant program. So states now have the power to determine what happens with welfare, to make any. They can drug test recipients. They can make terms of what they do with the money. And many states have actually only used half. The studies have shown they've only used half the block grant money for welfare, and they've used only half of it for welfare, and then used the other money for other programs that they feel better. But it's a block grant, and it increases the power of the states rather than the federal government. And that was an act that was temporary. Assistance to needy families, block grants I just mentioned, is a way to increase the power of states rather than the federal government. They can use the money in however they want to. They're not given any oversight. They don't have to do any accounting. They can spend the money based on how they see fit. They're allowed to use it because they know their citizens best. They know their way that they can um, serve their constituents. Then, of course, the 10th Amendment is the Reserve Powers Amendment, which basically states that if the power is not expressed in the Constitution, if it's not denied to the states, the power then goes to the states or to the people. So this 10th Amendment increases the power of states relative to the federal government. So the idea is gay marriage. It's not a power of the Constitution. The Constitution, that's not expressed power to Congress. Marriage is a states. It's reserved to the states. They can make rules and laws based on marriage. So they can deny gays and lesbians to marry because marriage is between a man and a woman per the state for the 10th Amendment. Same thing with education. Education is a state area. States can make rules and regulations based on the 10th Amendment. That's their power and what they can do. They have power over the federal government in education. So only select two of these. You can do the Welfare Reform Act of 96, which basically changed welfare, and it changed it to from a categorical grant to a block grant. States were able to regulate welfare, to limit welfare, and then block grants just in general, how they're been used in the 10th Amendment. The last essay is the United States Constitution ratification result from a political process that required compromise between Federalists and Anti-Federalists. Many of the debates in government today continue to reflect the concerns of each perspective. Compare the positions of Federalists and Anti-Federalists regarding the power of the national government. Describe two features of the original Constitution that led to a growth in the power of the national government. Explain how each of the following additions to the Constitution addressed Anti-Federalist concerns. Explain how one of the following clauses of the 14th Amendment has altered the balance of power between states and national government. Okay, so the position of the Federalists was they wanted to approve the Constitution without any changes to it. They didn't even need a Bill of Rights. The Constitution had the right to a jury trial. There was no religious test. It had its own. There was no ex post facto laws. There was no bill of tainers. There was no um, um, writ of habeas corpus. You couldn't suspend that. So the Federalists wanted the approval of the Constitution. They wanted a strong central government over the state governments, and the Anti-Federalists were against the Constitution. They didn't even want the Constitution with the Bill of Rights, but their only way to get their support would be add the Bill of Rights, but they felt that the Articles of Confederation was the correct form of government, and they wanted states to have the most power. So they Federalists wanted a strong central government. They wanted the supremacy clause of the national government. The Anti-Federalists wanted state power to be larger. They wanted the Articles of Confederation. They did not want a strong national government. They didn't want a strong president. They didn't want a strong judicial branch. The Federalists wanted a strong executive. They wanted a strong judiciary to basically regulate rules and regulations. Even you know Alexander Hamilton wanted the judicial judges to be life term. He even wanted the president to be life term and for life. So they wanted strong national government. The Anti-Federalists wanted a strong state government. They wanted the Articles of Confederation. So two features that led the growth in the power of the national government, that would be the implied powers clause, so anything necessary and proper. The power to tax and the commerce clauses were two parts to that were used to increase the power of the national government. And with the implied powers in the Commerce Clause, we got the Civil Rights Bill, we got Social Security, Medicare, we got the $15 minimum wage laws, we got child labor laws, we got the national parks, we got land grant colleges, we got the railroads, we got road systems. All of these things were through the implied powers, the Commerce Clause, and the power to tax. Also, the growth of the national government was the president and the able to be commander in chief and just declare war without declaring war, just sending troops overseas and sending troops in battle. In our history, we've only had 6 declared wars, and we've had hundreds of battles, wars, skirmishes, things like that, where the president's able to do that. So those, and then you have executive orders, executive agreements, you have executive privilege have all increased the power of the national government. The judicial review was not in the original Constitution, so I won't take that. So I would do basically the implied powers, the Commerce Clause, the power to tax, the president just being in that power. Now, how each of the additions addressed anti-federalist concerns. The First Amendment was the freedom of speech, religion, press. The federal government couldn't create a national religion, couldn't do these things. So the First Amendment addressed the concerns of the anti-federalists. The 10th Amendment was a really big amendment for the anti-federalists because it basically stated if it's not specifically written in the Constitution and it's not denied to the states, the power goes to the states. So both of those address the anti-federalist concern about the power of the central government, so the government could not create a national religion, it couldn't stop speech, it couldn't regulate the press, it couldn't make laws against these. So that was a real concern that the national government would be too powerful and they would overpower in your civil liberties and rights. And then the 10th Amendment gave power to the states. Explain how one of the following clauses of the 14th Amendment, you only have to do one, has altered the balance of powers between state and national. Both of these, the Due Process Clause, states cannot take away anybody's life, liberty, property without due process. And then there's Equal Protection Clause. Now, the Due Process Clause is for civil liberties. The Equal Protection is for civil rights. So you cannot take anybody's right to a trial or right to a warrant or gun or freedom of speech, freedom of religion without due process. And then Equal Protection Clause in the 14th Amendment. Both of these altered the balance of power between the states. It took powers away from the state. They were designed to take them away from the state. The 14th Amendment went after southern states because they were taking away rights from blacks and African Americans. And this amendment basically limited the states, and the national government could enforce this and do this enforcement. So the states could not take away people's property, people's life without due process. They couldn't. Every person had equal protection. They had to be treated equally as other whites. So blacks, gays, all different races, women have this equal protection of the law. And both of these gave the power to the national governments over the state governments. So those are the different essays that we have. Unit 1 essays, you have to do 2 of them. You can pick one argument essay, you have to do one argument, and then pick one other of the essays. I went over all of the answers. You do need to make sure to relate everything to the prompt. Remember to give examples for everything. Give examples of laws, give examples of agreements, give examples of things. Please do not write one sentence for the answer. You're going to get half credit if you just write a specific one sentence answer. This is essays. They're not necessarily 5-paragraph essays, but none of this says list. It says describe, explain. Now the argument essay, make sure to use your 2 pieces of evidence. One has to be from the required document. The other could be a law, a Supreme Court case. It could be the other document. And make sure to tie every piece of evidence to the prompt and tie every piece of evidence to the thesis. And then the others, please just explain, give examples, explain and give examples, explain and give examples. Don't just define something, give example, give this. Even if it says federalism, describe it, explain it, do it. Give a little bit more than just one sentence. I'm going to be looking through these. You may work with another person. I want you to write it in your own writing, but you can talk with each other what you want to do, bounce things off. But I tried to give you as much information as I could so you can do it without talking with others, to give you some ideas on what to say and what to write. You can research and Google things. The essays for this part, you only have to do 2. Remember, are due on Wednesday, and please upload them with your Kahoot answers and with the other items for this part. And you're going to be doing another set of essays again after this. Will be on in 2 days after this. So thank you very much. And if you have any questions, feel free to ask in office hours.